With your lordship grant permission, my lord, one matter was before your lordship in the Lok Adalat, last Lok Adalat. The party did not appear. It's a criminal miscase, my lord. 143A application has been rejected. My lord, your lordship had asked me to make a mention whenever your lordship sits, my lord.
No, but is it in this assignment?
Hello?
Is it in this assignment?
Assignment sabu CRLMC भी ऐसी सब.
No, no,
They-
these are for modification, clarification and all.
Only Setu.
Hmm. You move some application, modification or something, it may come here.
The problem is that, my lord, it is not being listed. 143A
That's the problem. I
application.
understand it, but what to do, you tell me.
No, it was before your lordship.
But I can't, because this assignment is specific
No,
assignment.
if it is not the assignment, then
That's the problem. Take it up. If it is
Whenever-
there in the assignment, I have no issue.
Yes.
With it.
Maybe pardon my lord, item number 11. Mr. Maharana is on accommodation.
And
Next week maybe.
11 and note karo.
Next week.
My lord, this is CRL matter. On this charges, my lord, listed however thila kintu hei na thila.
Everything will be listed, don't worry. We give your memo, it will be listed.
Yes,
Okay.
ma'am.
Yes.
Obliged.
Yes.
My lord, item number 4 not pressed.
Item 4. What do you want?
Instruction.
Wait, it will come. Item number 4 will come within 2 minutes. Wait. Please sit. I'll take it up. Okay. Please sit. Yes. Item 1. Any mentioning in the VC? No.
Item 1.
Okay. Yes. Any report? Got it? No. Huh? 1/7/2025 order.
Yes, report is there. Is there like?
Like, where is that report? After 1/7/2025? When is that order? When is that report?
Earlier it was in the list of the instruction is on that.
No, after 1/7/2025,
No,
have you
no.
got any report?
No.
Then I don't. The order dated 1/7/2025 has not been complied by the state council, and he seeks one more week extension. Keep the matter after 1 week. Get the report. Get a report. Perfect. Yes.
Item 2.
Here also, have you got report after 1/7/25?
No, madam.
Same order. After 1 week. Yes.
Item
3.
No report.
Last, but the indication was the court will take serious view. Since after long time this is now listed, I'll give one more opportunity.
It was listed.
16/12/25 order is not complied. 6 1 more. Okay. Yes.
Item 4.
Yes. 4 somebody was mentioning. Yes. Yes. What do you say?
My lord, item number 4 instruction no, not pressed.
What do the
For modification.
the counsel for the petitioner has moved and entirely stating that he has no instruction from his client, therefore he doesn't want to place the application. Accordingly, the same is disposed. Yes.
Item 5.
Item 5, my lords, I appear for the opposite party. My lords would kindly see the last order.
My lord, I am from the petitioner. On behalf of Biswajit Prasad, kindly taken up tomorrow, my lord.
Not tomorrow, but let us see what is this.
My lords, kindly see the last
Health
order.
condition.
9 lakh rupees.
My lords. Nothing has been deposited yet. As from the noting, my lords, I see that they have filed an IA for modification, my lords, of the last order.
Not deposited.
My lord, kindly take it up next week or more power.
My lords, I just want to inform one small thing, my lords. My lords, execution case was listed last week, my lords. Now, my lords, this has been the strategy from very long, my lords.
I'll vacate the execution of the stay.
My lords,
I'll
my lords,
vacate.
my lords,
My-
kind, my lords.
He is seeking one more opportunity.
Lord.
Day after tomorrow. Huh?
My lords, my lords, only one difficulty is that my grandfather has passed away. I'm doing the last rites. So I won't be available this week.
So what do you want?
My lords, next week, any day.
Tuesday.
Next Tuesday, my
Next
lords.
Tuesday.
Next Tuesday, my
Next
lords.
Okay. Next Tuesday.
Mhm.
Okay. Come with instruction, otherwise I'll vacate the stay. They'll proceed with execution.
Mhm.
Okay. Yes.
Item 6. 6, my lord. Find the earliest notification of the lawsuit order
Which order?
and the order dated 5/1/2026.
5-1?
2026. Under kind of glance, paragraph 6, Roman 6, my lord.
Hmm.
Now this is a case of 354B, 354.
Which
Your lord-
condition you want?
6, my lord. He shall be released on bail.
That's the whole difficulty. You, while
That I am
getting the
submit,
bail,
that I am submitting, my lord.
in every matter you have the problem.
No,
While getting bail, you say that
No,
any condition.
no, it
Once
is
condition is imposed, after some time you come, that's very bad.
Madam, the condition is correct and my submission, madam, I have having no criminal antecedent of similar nature, my lord. That I am trying to.
Two antecedent, my lord.
ठीक है, रोहित सर, मुझे convince कर दिए.
Hmm.
ठीक है,
I am already convinced. Don't worry.
madam, case and
This
counter
is the
case.
trick. While getting bail,
No,
you say
no,
that
no.
whatever condition you want, you put it.
No, what?
Once the condition is proved, thereafter application comes
Your lordship,
for modification.
lordship, I am bound down to your lordship. There are two cases, my lord, case and counter case. In both the cases, offences are most of, madam, 354B. In a 354B, I am in custody since month of November. Your lordship granted bail, directing that if any similar antecedent is not found. Madam, when I produced
What,
the
what
order-
kind of an antecedent
Again,
you have?
antecedent hochi, one case was of the where the antecedent.
Where have you said those things?
Flag R, my lord, kind of glance. Flag R, my lord.
Flag?
R.
Okay.
When the, man, the. in
You have been
shape of-
acquitted.
No, no, my lord. In shape of memo, the second page, when the antecedent report was called for, the police furnished that I have one antecedent. Another case in the year 2009 in which I had already been acquitted, for which that antecedent has not been reported. One antecedent, that is High Court PS case number 276 of 2022. The offences are 294, 3.
You do one thing, you file a comprehensive
I have
affidavit.
already filed, my lord.
Where is that?
Last occasion, lordship directed, I have already filed.
Where is that? Yes, comprehensive.
I
Have you verified,
That
Mr.
is
Apat? Have you verified?
The certified copy I have produced, my lord. The certificate which I am showing at flag R, it is the certified copy of the law and trial.
Para 6, you have said that.
Again,
Petitioner is
41A, he is the, my lord, the 41A. And whatever lordships are to impose the condition, so by the similar antecedent, if a person, my lord, granted bail in a 302 and a 294, the similar antecedent will be treated as in the highest offense. In the present case in which I have granted bail,
Don't tell me all the theory.
Sir, three-
Tell me how many cases you have.
ସେ ଗୋଟେ ଆଜ୍ଞା ଅଛି ଆଉ ଗୋଟେ
That is para 6.
506 କେସ୍ ମାନେ ନଭେମ୍ବରରୁ ରହିଲାଣି
Data case ଅଛି, my lord.
Sir,
Yes, my lord, I have 1 week time, I have filed affidavit.
they have granted bail by the coordinate
That's
bench.
right, but he says 2 cases.
ମୁଁ judgment ଦେଇ ଦେଇଛି ଆଜ୍ଞା ସେ ଯୋଉ two says
The other case you have been acquitted.
I have
Where,
been certified copy my lord
Okay, one-
ମାନେ flag R my lord kind of glance
where have you said in that?
flag R ରେ ମୁଁ ଆଜ୍ଞା ଦେଇଛି certified copy
1 week time, my lord, I will give affidavit.
Before I ask a question, you answer it. Where have you said in the comprehensive affidavit that is,
ଯେହେତୁ ପୋଲିସ ମନରେ
have you heard my question full?
ଆଜ୍ଞା ଆଜ୍ଞା
No, you have not. You don't have patience.
but,
That is how you spoil your thing. When a judge is asking, please hear the question full, then answer it. In the comprehensive affidavit,
ମନରେ ଆଜ୍ଞା ଗୋଟେ କେସ୍ ଅଛି ସେଇଥିପାଇଁ ମୁଁ ସେଟା ଲେଖିଛି ଆଜ୍ଞା ମୁଁ ଗୋଟେ କେସ୍ ଲେଖିଛି because
I'll hear it next Tuesday, okay?
ଆଜ୍ଞା, ମୁଁ
You develop
November-
patience within this week, okay? Tuesday, this is
ଆଜ୍ଞା,
okay. You develop patience, I'll tell you, you
I
have
have
to
the
develop
paper.
patience, otherwise you are going to spoil your case. I'll reject it, what is the use of it? I would have allowed it, I know what is the limitation, I'll do it, but have patience, okay? Next Tuesday.
Sir, they have been granted.
Okay, well, Thursday.
Thursday.
No, I will not do today because you have crossed the barrier. Thursday. I'll do it, don't worry. And you, on Thursday, you tell me what are the 2 cases. You say 2 cases, this is 1 case. 1 case he has filed a comprehensive affidavit saying that the 1 case particular he has given. What is the other case according to you? Tell me on Tuesday, Thursday, day after. Okay.
ସେଇ
Let him get it. And you
say
develop
judgment-
cases by that.
ସେ ଯୋଉ ଡବଲ କେସଟା କହୁଛନ୍ତି that judgment I have filed already man. That I am sorry.
But before I ask the question, you are answering it. Day after, okay?
ସେ ଗୋଟେ ପାଞ୍ଚ କେସରେ ସେମାନେ ବେଲ୍ ପଳେଇଲେ ମୁଁ
Okay, day
ରଖିଛି that is
Day
the-
after, let him have the satisfaction of bringing the other case particular, okay? ଆପଣ ଦେଖି ଦିଅନ୍ତୁ ଯଦି ଆଉ କଣ କେସ୍ ଅଛି ବୋଲି କହିବେ then we'll see, okay? Day after.
Thursday right?
ହଁ, Thursday.
Item 7.
And then tomorrow you have that moan breath one day. Don't speak. So day after tomorrow you will perform well.
In this case, pursuant to direction of this report dated
Seven, huh?
12/2025 to file an affidavit. They have filed affidavit, but copy not served, my lord,
You are appearing for?
for the petitioner, my lord.
Lordship, I am appealing for the opposite party.
Copy may be served, my lord. One affidavit.
No, why for this application? Why this matter has come?
Well, kindly see the cancellation of bail. Kindly see page 10, my lord.
Page 10 of?
Annex 1, page 10, dated 12/3/2024, para 3. The allegation against the petition is that he has entered into an agreement with the informant on 26/2/2020 and has taken a sum of rupees 47,70,000 rupees on a promise to sell the house to the informant in Acharya Bhubaneswar.
Yes.
It is unadmitted that the petitioner has indeed taken the entire money from the informant. However, neither he returned the money nor executed the sale deed in favor of the informant so far as the property is concerned. The petitioner is in custody since 5/1/2024. The petitioner has brought a draft of 5 lakh rupees in the name of the informant on his own violation and on instruction. Town counsel for the petition undertakes that the entire money he shall pay to the informant within 6 months. Hence, he submits taking the undertaking on record. The petition may be enlarged on bail. Mr. Biswal, on counsel for the.
Thereafter he has not paid anything.
My lord?
Thereafter he has not paid anything.
No, my lord.
Lordship, I am appealing for opposite party.
What do you say?
Affidavit to last occasion directed to file an affidavit. What amount has been paid? So I have filed the affidavit, but copy has not been served.
According to you, you have paid.
I have paid 5 lakhs.
No, what he says, 5 lakhs you have paid, no problem.
Right.
You have also undertaken that you will pay the rest of the amount within 6 months. So that is why he says.
Last occasion, Lordship directed to file the affidavit. In the affidavit, my argument is I am ready to give the amount 3 lakhs rupees within 1 month, and rest amount I will pay the 6 lakhs because my economical condition is so serious, sir. And now trial is in flagging stage. In IO stage, sir.
What cancellation? See, the Supreme Court says that these are not recovery proceedings. Because he gave a statement, 5 lakh rupees he has paid, 3 lakh rupees he want to pay, and he files an affidavit. Cancellation may not be possible.
First,
Because at the fake end of the trial, the IO is being examined now.
well, first affidavit copy may be served. I will take
Okay.
instruction from the.
Okay. The opposite party number 2 has filed an affidavit. Affidavit dated 6th January 2025. The copy of which has not been served on the petitioner. Therefore, he seeks adjournment to adjournment. In the meantime, the counsel for the opposite party number 2 shall supply the copy of the affidavit to the counsel for the petitioner. Okay. Release the matter. Release it after the 4 weeks. 4 weeks. By that time, the trial will be over. Yes.
Always.
Thanks.
Item 8.
My pleasure, Lords. I will give a matter for cancellation of bail. My lord, kindly see page 19, my lord, minors of granting bail. Paragraph 5, page 19, my lord, 19. 19,
Okay.
running page.
Hmm.
Paragraph 5, the victim was directed to remain present in the court in presence of the IIC Dhawli police station to the video conferencing mode. The victim appeared before this court through VC mode along with the IIC Dhawli police station. He has expressed her apprehension that if the petitioner will be released on bail, he may threaten her. Therefore, he showed that even if the petitioner is enlarged on bail, he should be put to such condition that he will not be harassed in any manner.
Hmm.
After getting bail, my lord, he was harassing the petitioner, my lord, and
Have you complained?
yes, my lord, Annex 1, your lordship, may kindly see.
Yes.
Before the Dhawli police station, my lord, I have lost the affair. Yes, madam.
My lord, first of all, what is the submission, my lord? My lord, initially they lost affair from only a single document produced. There is one name Dipti from the said ID. There is a threat message that we have to circulate the photographs. That is the allegation. From what ID that is belong to the petitioner?
No, I'm not on merit.
Again.
If there was a condition that you will not threaten, again.
Present petitioner not at all threatened. They created itself a ID and for the same
What do you say, sir?
You can take instruction that.
You take instruction.
cyber also.
I'll have to cancel the bail if.
My lord, I also given a cyber cell regarding the same way acknowledgement receipt also I received that Mo Nako fraudulently using my name.
Let the state verify it and tell me.
My
Let the notice was issued.
yes, my
Yes,
lord.
ma'am.
I am appearing for OP number 2.
My lord, my learned friend's name is not in the V now.
On behalf of Mr. Goraknath Das, I am
Give
appearing.
your
Mine.
right.
Mine.
Let the council for the state seeks one more week adjournment for obtaining supplementary matter, least matter after 2 weeks. Yes.
Obliged.
No problem.
Item 9.
Item 9, modification of order.
What modification?
Instead of SDGM Baripada, the same has wrongly typed as SDGM Balesur.
Para 5, yeah? Balesur. Baripada, it should be
Baripada.
Baripada. It should be Baripada in place of Balesur. Okay, enough. Yes.
Obliged.
Item 10.
May I please, your lordship? In this matter, your lordship, the judgment was reserved already.
Written notes of submission.
Submitted. I have already filed, but perhaps I'm verified in the records. It is not there on record, your lordship.
You verified.
I've already filed. I have a
No,
copy.
you have to give an exhaustive one.
I just one I have given you.
Some cheat you are giving.
No.
That's a big matter.
No, I have
All
given.
judgment, relied upon judgment, everything is
Yes,
enclosed with that.
Yes, your lordship.
You file it then.
I have already also filed.
Yes, you have already filed.
Already filed.
And counsel for the petitioner. Yeah, are you filing today?
Yes, your lordship. On 6th 2020, I've already filed, but I'm giving another copy. Perhaps it's not done with the registry.
Submits that he has although filed the written note of submission, but it has not come on record. He undertakes to place it on record during the course of the day. Okay. Okay.
I'll give another copy, your lordship.
Yes.
My lord, in this matter, I am appearing Union of India.
Okay. You give your appearance. Appearance.
My lord.
Just give. Get the chairman matter. Yes.
Much obliged.
11 mention करते हैं तुम्हारा item 11 mention करते हैं
Yes.
Hearing.
Mr. Marana has mentioned in the morning.
Madam.
Is not well. It's some issues.
Madam.
You tell me when can I put it? Give you a date.
18th, my lord.
18th is the.
Or otherwise, my lord, just give me after 28th.
You relaxly think over and give the date.
Madam,
So
madam.
according, yeah?
Madam.
Relax, give the date, we will fix that date.
Madam.
Okay.
Hearing.
Yes,
Item 12.
item 12. Ready?
Yes, my lord.
We just pass over once, huh? Item 13.
Item 13.
The problem, nobody comes then.
Certain bench.
Hmm?
Certain bench is asking.
Excuse, yes, Sahu. Appellant number one, item 13.
Yes, my lord.
Appellant number one has died,
Yes.
and this is now confined to
Appellant number
2, 3, and 4. 2, 3, and 4. Last time who appeared? Last time Mr. Sahu appeared. Yes, Sahu. With Mr. S. Sahu. Huh?
Yes, sir.
Amicus? No, no.
Yes, sir.
Amicus now.
Well,
On 25/11 non appeared.
25/11 non appeared. What about 14? Let us see 14.
Item 14.
Fourteen also, last two dates, none, nine.
No,
12 as well as
in the
15.
last date of hearing, it is said that it is made clear that if none appears on the appellant on the next date of hearing, this court shall appoint amicus curiae to assist the court in the matter. Nobody is there today. What is the offense here?
Offense, my lord, under section 366 and 376, sentenced to undergo array for 7 years under section 376 IPC and on 4 years under section 366 IPC.
7 years.
So far as appellant
is
number
matter.
1 is concerned. So far as others are concerned, sentenced under section 109 in IPC for abetting.
It is matter. Mr. Zagda, you have to, because 7 years sentence. It's, youngster can't do. Some, and somebody should assist you also, so that I'll request anyone who can assist, you can assist also. Write down both name, Mr. Zagda will lead, and you will assist him, and next matter we will keep, and Mr. Ragada and so are appointed as amicus curiae, and no, in the last date of hearing, it was made clear that if none appears for the appellant on the next date of hearing, amicus curiae will be appointed. When the matter called up today, none appeared for the appellant. Hence, Mr. Ragada and so will be appointed as amicus curiae in the matter to assist the court. This is the matter. And Thursday, you take it in pen drive, prepare and take it with him. Talk it out, okay? Yes. Next.
Item 15.
15. Yes, sir.
And it's Thursday and it's taken. Thursday, my sir is not here actually. Thursday. Sir.
No Thursday. I'll pass it over. Ask because 94, 95 matter I'll not adjourn. I'll just pass it over. Tell sir, huh? Okay. And 16.
Item 16.
DS Tripathi.
DS Commission.
498. DS Tripathi. Oh, pass it over once. Once I have to pass over, otherwise.
55 years. Reporters.
65 years, surviving. Yes. Well, once I'll pass over. 17.
Item 17.
Call for NCR, these matters. Mr. Dhol. This is also Mr. Dhol's matter. Who he is appearing, no, for Mr. Dhol. You are appearing for Mr. Dhol. You are from the office of Mr. DP Dhol.
Yes, sir.
This is matter is your office matter.
Item 18.
15.
Huh?
17.
That's item is
17, huh?
Acharya.
Okay, 17. 1 minute. That's 17 is. 18 is yours, 17. No, but in 17 also, you see, Udaynath, na? 17 is Udaynath, but his appearance is written here. Udaynath Sahu. In the proceeding dated is 16/12/2025. 16/12/2025. Mr. Dhal's appearance is there. Therefore, I am saying. Let's check it up. Whether 17 also is your matter or what?
NCR was called.
NCR is called for, and your appearance is written here.
I will check it then.
Mr. Dhal, senior counsel. Check it up.
NCR was level.
Huh? LCR Rasini. LCR has not come. I'll just pass that order. Although on 16/12/2025, the TCR for the case was called summoned by this court, but the digital copy of the TCR has not yet been received by registry. No? The registry is directed to make sure that the TCR is called forth for the release the matter.
Flag white.
Flag?
Why?
Why the what? Could not be traced out. So I'm not unable to trace it from the 1 month time. So लिख दो इसको. नहीं इसमें लिखो. Although on 16/12/2025 the TCR case was called for. However, by the 8/12/2025, the first additional district session judge Khuda has requested for 1 month time to trace out the record and transmit the same to this court. Already 1 month has lapsed. Therefore, the registry is directed to coordinate with the first additional district and session judge Khuda and the setting summoning of both. Yes. 18.
Item 18.
Pass over, yes.
Item 19.
Yes, sir.
Fine.
Ready? Start.
So, I have already filed my notes of argument. Criminal conviction under section 20B1 LDPS Act. And the sentence is 4 years. Fine is 25,000. 2 appellants, one has expired.
This is item 19, huh?
Yes.
Item 19.
Item 19, yes.
2 appellants, one has expired.
Yes.
But the case is that
Who has expired? One.
Vidyadhar Sahu.
Two has expired. Vidyadhar Sahu. Okay. Now it is only one. It's for only one. Yes,
My lord. Here, my lord, the case is that the constable, GRP, he detected contraband. That is what his prosecution case is. He detected contraband in a running train.
Yes.
He asked them whose things are there in the bags in the article. The contraband said that he smelled and he asked them, and he said that they had expected these are their baggages, and he got down at the next station, Kissinger, and there he says that I called my colleague, and thereupon from platform to the police station, he carried the baggage along with the accused persons, appellants, and at police station, arrested and seizure was made.
Who is that witness?
My lord. The constable himself,
PW1.
PW1.
Let us read the PW1. Yes. I know both the questions standing in the law. The occurrence took place on 14/10/2000, the day of Dasara. On that day, I myself and the constable, 18, Gordon's house from so. A few others of Titlagar being deputed were performing the train guard duty in Hirakonda. The Kesinga station. I went inside the first class apartment, and there I found both the accused persons were sitting in the compartment. Besides them, no other passengers were there. Besides them, no other passengers were there. No other passengers were there in the said compartment. In the said compartment, I noticed and 2 airbags. The attaching towards the lock out of the 2 airbags. So one was locked and the other was without the lock. While the train was moving, I asked a couple of the countries suppose what's convenient. Yes,
Well,
the smell of ganja was coming from suspicious, I asked. By that time, the train was about to reach it like they lacked them. Yes,
my lord.
yes, I got it.
Mhm.
Tell me,
Here, my lord,
what is your case?
my case is that nothing is detected from me, and they have not proved that it was from my concept, from my position. That is it. Or see my notes of argument,
Hmm.
my
Where-
submission.
Where is
part.
your notes of
But I
argument?
have already filed it.
Huh?
I filed it
You
earlier.
filed it? Yes, your notes of argument.
My lord.
Hmm. Yes. Yes.
Let here, my lord, a complete go back to the independent witnesses
Hmm.
and relying on the police officers for the purpose of conviction and sentence.
Mhm. Yes.
The independent witnesses, as per the observation of the Honorable Court, at para 5 and 6 of the judgment, this is that they seems to have turned hostile, but they are not declared hostile. 4, 5, 6, 4, 5, 4, 3, 4, 5.
Hmm.
They were not declared hostile, my lord. The court says at paragraph 5, page 5 and paragraph 6 of the judgment.
You written note, you come to the written note.
My lord,
What are you trying to say that? Read the note.
may I read out the,
Yes. Fact you read, come to para 4.
my lord,
In order to prove the case, prosecution witness
my lord,
examine 6 witnesses.
my lord.
Period 1, what he said. Informant.
Purushottam Mahapatra is the informant, the constable of GRPS, who was performing train duty on the date of occurrence, along with Constable Govardhan Sahu, Bonmali Naik, and 2 others of Titlagarh PS. He has stated to have got off the train at Kesinga station and had found the appellant in the first class compartment. He has stated that other than the appellant, no one else were present in the compartment. He stated to have noticed 3 attaches, 2 airbags in the compartment. The 3 attaches were locked, and out of the 2 airbags, 1 was locked. He has stated that the appellant had claimed ownership of 3 attaches and 2 bags. He has stated that he had smelled ganja in them, and he has confronted the same to the appellant, who admitted the contents to be ganja. The appellant could not produce the authority of such position. The train, when stopped at Titlagarh station, he called his colleague and carried the 3 attaches, 2 bags, and the appellant to the Titlagarh GRPS and submitted written report. He has put the written report, Exhibit 1, and his signature Exhibit 1 by 1. He has further stated that the keys were kept in the airbag, and the appellants brought out those keys from the airbags and handed over to the OIC. And when the bag and attaches were opened, they found them containing ganja. He has further stated that he has witnessed the weighment of contraband. He has admitted that he has not signed on the original seizure list. He has proved material object 1, 2, 3 as the attaches and 4 and 5 as the airbags. He has also stated in his evidence during his cross-examination that ganja kept in attache and airbag were weighed at about 5 p.m.
Yes.
My lord, PW2, Kholi Swine, is a colleague, my lord, was a constable on duty on Hirakud Down Express, stated to have been on duty along with PW1 on the date of occurrence. He has further stated that PW1 was standing at Titlagarh station and he called him and told him that a line is missing. He has stated that he was on duty along with PW1 on the date of occurrence. containers contain ganja. He has stated that the applicant carried the metal object from platform to GRPS, where it was given to OIC. He has stated that he cannot say if it was a false case and that handing over the articles, he left GRPS.
Come to PW6.
My lord. Sarat Chandra Dolabera is the investigating officer of the
Yes.
case. Yesterday, PW1 had produced the appellants 3 attaches, 2 airbags, and a written report before him at GRPS on 14/94. That means the date, my lord, 14/94. He has registered the case, taken up investigation, intimated his higher authorities, inspector and SP, stated to have seized the attache and airbags containing ganja, stated to have taken payment of the ganja before PW4 in presence of witnesses. He has stated to have collected sample in presence of witnesses and appellants. Arrested the appellants, forwarded them along with the seized articles to court. He has stated to have sent samples to RFSL, Hon'Ble, for chemical examination. He has provided his signature, proved his signature at Exhibit 2, 2/3. He has proved Exhibit 4 chemical exam report. He has proved the metal object 1 and 5. He has admitted that it was his first place, my lord, under NDPS Act. He has not prepared any spot map since the recovery was from the running train. He has stated that he has no personal knowledge when the accused was caught hold of. He has stated that he has not visited the house of the appellants. He has stated that he had sent the samples for chemical exam on 15/11/94. He has admitted that GRPS and other officers such as RMS of railway canteen is in one row and adjacent to each other, and he has not called any person to witness the search and seizure who usually remain present in the platform. Para 4, page 52, PW6. He has stated to have informed the fact of such seizure and arrest to the appellant to his next higher authority, and that he had mentioned the same in his CD, but he has not mentioned the exact time of it. He has stated that at the
Come
time.
to Para 7. Come to Para 7.
Madam?
So come to Para 7. Your
Madam.
permission. I read it already. Yes.
It is stated in FIR that approximately 25 kgs of ganja.
Para 7 of your written submission.
My lord. The learned court has given much emphasis on the evidence of the official witnesses and given a complete go-by to the evidence of the independent witness, more particularly observing at page 5, para 6 of the judgment, that PW 3, 4, 5 seems to have turned hostile to the prosecution, whereas they were never declared hostile in course of the trial by the prosecution. The evidence of appellant 1 as DW1 and the platform ticket proved by him, while Exhibit A has not been discussed even for the sake of probability factor. That the witness PW4, who is stated to have weighed the contraband, has denied the material object MO1 to 5 to be the ones he had seen in GRPS. Titlagarh, he had also stated that he cannot say why the contents were weighed. It has also not been brought out from him by the prosecution that the article that he weighed was ganja. Similarly, the evidence of PW3 runs contrary to the mannerism stated to have been adopted during seizure of contraband and collection of sample. Rather, he says that at 7 a.m. he had seen appellant number 2 and appellant number 2 near the overbridge and some police near the articles in GRPS, which runs contrary to written report of PW1. So he says he carried him. That the train reached Titlagarh at 8 p.m. This strengthens the defense of the appellant that he had come to the platform of Titlagarh station to receive a friend and that he was forcibly taken to the GRPS. This is the defense one. The evidence of PW5 also goes to show the irregularity committed at the time of search and seizure and collection of sample when he has stated that he has not seen the actual seizure. PW5. The learned trial court has given a complete go-by to the factual aspect while only discussing the peculiarity of the case in law with regard to the compliance of mandatory provisions and its non-application in the peculiarity of the case, particular term used in the judgment. The evidence of Schedule 1 cannot be relied upon without any corroborative support on the point of detection. More particularly, when he says that the entire compartment only consisted of the appellant and the baggages in a running train, and he had neither brought it to the notice of the TT or his colleagues instantly present in the train. The story of detection is highly improbable. The question of appellant traveling in the train is addressed superficial by the trial court, observing that he was traveling without ticket. It was never the case that he was traveling without ticket. And that the same has produced the appellant. The evidence of Schedule 2 does not corroborate Schedule 1 with regard to the aspect of detection of contraband from the appellant number 1 from the train, and the same also does not find support from the evidence of Schedule 6 when he says that he had no personal knowledge when the accused person were caught hold of. Paragraph 3, page 6, PW6 evidence.
Yes.
He has further stated that he had not prepared any spot map. He has not visited the compartment from where the accused persons were caught hold of. He had admitted that one TT and one attendant would attend in every first-class compartment. Hence, the trial court failed to appreciate the detection of the appellant number 1 and the contraband was from class 1, first-class compartment of the Hirakud Down Express. Is not proved and lacks corroboration even from the evidence of official witnesses. Schedule 2, who has stated that Schedule 1 was standing on the platform along with the accused persons and the container. He called them to go to GRPS and they went there, and that during duty of the train he had not gone inside the compartment from where the articles were recovered. The prosecution, though, has raised the aspect of admission by the accused that the attachment airbag contained ganja and they were the owners of the same before Schedule 1 in a running time, but no such admission was neither fortified by judicial recording nor was discussed by the learned trial court. Hence, it is submitted that conviction could not have been based on the evidence of the official witness in the peculiarity of the case, in as much as Section 51 DPS Act raises presumption and the burden shifts to the accused to explain as to how he came in possession of the contraband. But to raise such presumption, it must first be established that a recovery was made from the accused. The learned trial court could not turn Nelson's eye to this aspect, whereas in a category it has been observed that Section 42, 43, 49, and 51 DPS Act are scrupulously followed by the detective agency, as once possession is proved, Section 54 in DPS Act, the accused is presumed to be guilty of the offense. My lord, relate one judgment.
Yes.
Hence, in the case at hand, recovery from the appellants once not established.
Yes, I read it.
Madam.
Yes.
Here, my lord, this case, my case simply lies on the fact on detection. Says that one constable says.
Why should the PW 1 and 2 will be doubted?
The defense is that they were asking for some subscription because these appellants, as they say, they were not traveling in the train. And they had proved a platform ticket as well.
Platform ticket is recovered from them.
One of them. One platform ticket.
One platform ticket.
And it was dealt like it is very common to have
from
platform.
which position? Platform ticket recovered from which position? And what is the exhibit?
My lord, 2. Exhibit B.
Where is that? It is recovered from whom? Whose pocket?
During the course of trial, he was examined as DW2.
No, from whose pocket the platform ticket is recovered?
No, he exhibited. He brought it to the notice of the court that.
No, that is
Well,
neither here nor there.
But here.
Is it recovered from the possession of any of the accused? You can buy it and produce it
that is
subsequently.
that is exactly how the court had dealt. Trial court dealt it. That you could
That's
have.
obviously
Because
see, the platform ticket is not in the name. Okay.
Exactly.
It can be collected. Someone else may be having that. It can be collected and exhibited.
Exactly.
How will you relate it unless it is recovered from your position?
Yes, my lord. But it is only during my defense I had presented it because you were never seized from me.
Rightly, trial court has rejected. rightly tell. Then.
Thereafter, my lord,
The IO says that it is.
IO says,
Found in the possession.
I
Section
doesn't say
50
about this platform.
Section 50 was not complied because
It was
there
a
is no
running.
personal search at all.
No personal search.
There is no personal search.
Because it
50
came
was not
baggage,
required.
came in the baggage and
50 was not required. So therefore, if 50 is not complied, not required to be complied, then there is no question of any recovery from your position, anything.
well,
So therefore, the platform ticket is not recovered from you.
well,
In defense, if you have brought something,
yes, my
saying
lord.
that it is
Because that is the only material I had, and I could only present that thing,
that-
and nothing else. And that apart, my lord, the independent witnesses. Independent witness, my lord, may see. This,
what is the sentence?
My lord, it is 4
4
years,
4 years.
my lord. 25,000.
20B1, huh?
Even the person weighing the contraband, he also doesn't know what was it. He stated that in his evidence. I cannot say what was it.
Yes. Yes, anything else?
My lord, the vehement Yoguram Gupta. So he says, my lord, that I was there at about 10 to 11 am.
Where? Where?
PW4, my lord.
PW?
4 at page 23.
Yes.
48, my lord.
Yes.
All the attaches were covered. Police Babu opened the attache and thereby I was asked to weigh the contents, my lord.
Where you are reading?
My lord, para 1, the chief. All these 3 attaches were covered. The police Babu opened the attaches and the airbags. I was asked to weigh the contents of the attache and the airbag. On my weighment, the articles came around 30 kgs. Then he goes, I cannot say, my lord, para 4, almost 1 to 3, not those attaches which I had seen in GRPS. I cannot say if MOs 4 and 5 were the 2 airbags which were kept in the GRPS. I cannot see why the contents of the
1, 2, and 3 were not those attachments which were.
I cannot say why the contents of these attache and the airbags were weighed. Nothing about contraband, my lord.
He is the
Weighing.
independent witness.
Yes, ma'am.
He has not been declared hostile.
No declared hostile. None of the independents were declared hostile. But the court held that they were hostile to the prosecution case.
May not be declared, but they are hostile. The trial court deals with this when? Where? Yes. Which paragraph? Deals with paragraph 4.
At page 5 of the judgment, my lord. Thus, PW 3, 4, and 5 seems to have turned hostile to the prosecution.
I'm reading it, that part.
My lord.
seems to have been turned hostile.
Yes, my lord.
Come and read para 9. Madam, para 9. Compliance of 50.
Alright. Now coming to section 50 of the NDPS Act, undisputedly there was scattered distance laying down the proposition law that section 50 of the NDPS Act is mandatory and non-compliance of said provision renders the search and seizure vulnerable. Section 50 provides that when any officer's duly authorized under section 42 is about to search any person under the provision of section 41, 42 for he shall, if such a person so required, to search such person without unnecessary delay to the nearest gazetted officer of any of the department in section 42 or to the nearest magistrate. The near reading of the above mentioned provision suggests that such provision applies to the search of the person, not the search of the place. The peculiarity of the case is that the constable found 3 attaches and 2 airbags were inside the first class compartment of the running train, that is Hirakudan Express, where the accused persons were the only travelers having no tickets with them. The accused person, on being asked when claimed to be the owners of the articles, PW1 brought them to the ERPS, where the articles and were produced before PW6, who seized the same. It stated in the case law, State Punjab versus Balbir Singh, referred to above, wide paragraph 6 of the judgment that when a police officer carrying on investigation including search, seizure and arrest empowered under the provisions of the CRPC comes across a person being in possession of such narcotic drugs and psychotropic substances then two aspects will rise. If he happens to be one of the empowered officer under NDPS Act, he must follow thereafter the provision of NDPS Act and continue the investigation as provided thereunder. If on the other hand, he is not empowered, then the obvious thing he should do is that he must inform the empowered officer under the NDPS Act, who should thereafter proceed from the stage in accordance to the provisions of the said Act. But at this stage, the question of resorting to section that is informing the accused that if he was so wanted, he would be taken to gazetted officer, and taking to the gazetted officer thus would not arise because then such would have been over. As laid down in section 50, the steps contemplated thereunder, namely informing and taking him to gazetted officer, should be done before the search. When the search is already over in usual course of investigation under the provision of CRPC, then the question of complying with section 50 would not arise. In the case in
Yes.
hand,
So that is the logic.
no,
Personal search for the purpose of personal search 50.
no, but before that, my lord, I would press on the fact that detection. One constable finds
No,
person in-
I did see 1, 2, and 6 you can't doubt.
My lord, there were other persons in the he says the IU says there must be railway officers, one TT and one attendant in every compartment, and that apart,
That is the prudence of the prosecution.
my
Prudence you can't
difficulty-
say that this witness should have been examined, that witness
my
should
lord,
have been examined.
there is no witness cited by them.
Not necessary.
There is no
If they
witness
could
cited by
prove
them,
the case by
and I
examining-
stand helpless.
If
I
they
stand
could
helpless.
prove the case by examining these 2 or 3 witnesses, why should they bring many of them to create problem for themselves?
My lord,
And second thing, but Lordship, they have proved their ownership. They are saying that attachment belongs to them only.
I have that is the point. I never that was never stated, and they have never converted into a judicial
In the
confession part.
compartment, they were sitting together. There was no one. That the evidence has come.
That
And
is
the baggages were there.
that is what the for PW1 says. PW2 sees the PW1 and these two appellant on the platform with the baggages.
Yes.
Never from the train. Never, he has never seen them in the train. Only in the platform.
No, PW2 says that.
Yes, my lord.
But PW1
One says that I detected, I brought them down.
brought them. Thereafter, they called PW. He called PW.
He called his colleagues.
Ah.
They say that we have not seen.
Obviously, the train went thereafter.
No, my lord. They were all in the one train. They were all in one train.
In another compartment. Just see.
Yes,
That is the narration goes. That is how the narration goes. They were in other compartments. And in the Kitlagat, they got down. Thereafter, he called everyone.
Yes, my lord. That is it. That is exactly.
These are minor, this thing, variations.
Because
How much you have already undergone?
I have
Talk about the sentence now.
I lost it somewhere.
Tell me how much you have got.
I was 9 months, 25 days.
9 months, 25 days.
My lord.
What is the minimum sentence? Let's see. Sentence. B1.
Which may extend to 10 years.
Extend to 10 years.
Extend to 10 years.
And fine. 9 months you have already undergone.
My 9 months, my lord.
9 months? When you got the page, let us see.
Within 9 months, 28 days. Huh, 9 months, 25 days. 15/10/94 and were released on 9/8/95.
Arrested on
15/10/94. He was produced on 15/10/94.
15
10/94.
10/94.
And he was
Bail?
released on bail on 9/8/95.
9/8/95.
95.
So then it is 9/8 October. What is October? Eleven month.
My lord.
11 month something, 11, 15, November, December. I don't know.
Fifteen 15/94.
Ten months, 15 days, and 10 months. He was granted bail here. When the judgment? The bail was granted on 28/7/95. Judgment? Bail.
13/6/95.
13
6/95.
6/95 judgment. Yeah, after judgment also 13/6/1995 and 28th July 95. Another about some 20 days or something. Anyway, about 11 months. About 11 months. I'll modify the sentence. Yes. Okay. Okay.
Chip, I also made a short date chat. Can I?
Huh?
Short date chat. I have also.
You please give. Yes. Next. Item 20. Awesome. 21.
Item 21, may I please, your lordship?
Yes.
My lordship, kindly adjourn this matter to next week as my senior
No,
is
it will not be
unwell.
urgent, madam. It 95 matters. It will remain in the list. You get ready. I
My
will
lordship,
not urgent.
my senior is not well. Kindly take another day.
No, today I may not take, but it will remain. Yes. 22.
Obliged.
Your lordship, I need some time to prepare for this case.
Whole day is there. You prepare.
Your lordship,
Come at 3 o'clock.
Your lordship,
See, these are 95 matter, madam. What is wrong in it? You just see, read it. How much time it will take? Read it. We'll read together.
Your lordship, next week.
I have also not read it. We'll read together what is it. Not next week. It will remain like this. You prepare. Remain. Let it be in the list. Okay. Yes. Get ready. You take the pen drive and get ready. Ready. Yes. Next.
23 date check.
23
date check.
It was heard, huh?
Yes.
Pass over that thing. Yes.
Date check.
Let it be there. Yes. Yes.
24
Yes.
25
Awesome. At the top, from tomorrow, at the top you write down the 95 matters. Twenty.
25
Yes, 26.
26
What is there? What is the problem?
Year old cases.
Huh?
Puna cases is the ରହିଯାଇଛନ୍ତି ଆସୁନାହାନ୍ତି।
Therefore, I am saying that from the cause list only we will write from tomorrow onwards that if the counsel for the appellant will not come, we will appoint amicus curiae and
Yes, that's good.
so that indication should be there. We can't wait, see 90 matters, then it will never be, heard. Yes.
And if it will be common the weekly list, that is the.
These are weekly list only. It remains in weekly list. I'm not altering the list. This is weekly list. This will remain like this. We are not changing.
जोड़ाक Sunday जो publish होची जो list टा सेटा हेले so that
they will be prepared. Yes. Yes.
26
Anybody is ready? Any matter. Yes. Mr. Roda, are you ready? 32.
32. I will take 5 minutes, sir.
Okay, 32 is, we'll do it, 32. 80?
83.
We'll do it. We'll do it. After 12 o'clock, we'll do it.
Yes.
You can relax. 83, na?
Fine.
No problem. 2009. Yes.
32, my lord. This case, my lord. Charge frame under section 498A, 304B, 302, and 34 IP, section 4 of the DP Act, my lord. Lord, the 3 persons face the trial, my lord. The husband of the deceased and one mother-in-law and the present petitioner, the appellant is the father-in-law of the deceased, my lord. All of them acquitted all the charges except this, my lord, man, father-in-law, convicted on section 4 of the Dowry Prohibition Act.
Okay.
My lord.
Father-in-law.
Father-in-law, my lord.
Even husband is acquitted.
Husband acquitted, my lord. Only because, my lord, the charge when the court below framed the charge, my lord.
And wherever the sentence is more than 5 years, along with some youngsters, some senior lawyer is also to be appointed because 7 years and 5 years, 7 years.
One case is engagement.
He is there. Likewise, the junior one, senior one.
Better, my lord, better.
So that both these people may not have time, na? They are giving this much time. Is big thing. You just write the senior person's name and junior lawyer. Prepare a list. Senior, junior. अभी जितने मैटर है सब बड़े-बड़े मैटर हैं.
May I pardon that? Item 49, a case of conviction, 3048 causing death by negligence, 2 years conviction, and in custody for around 10 months. The difficulty, the last occasion, I missed the fine from the court itself. So I want to have a copy of the brief.
You take it.
Yes, I am copying to the. Week
Yes.
6 row.
Huh?
226 days order.
Achha, last occasion, they
You already undergone substantial period.
yes, that
We
is-
can convert that if you want.
Yes,
Just check it up if you
Yes,
can
yes.
be done it today. We can.
yes, yes.
Yes.
My lord, for item number 34, I am appearing on behalf of my learned friend, Miss Sinha. Can it be taken off on Thursday?
It will remain on Thursday, no problem. You get ready. Huh?
Permitted to take the LCR copy, my lord.
Take it. Yes. Yes.
Pardon me, your lordships. Item number 55, your lordships. On last occasion, your lordship instructed that if no one appears on behalf of the appellant,
I have not instructed anything.
there is this order, your lordships.
Hmm?
There is
No,
this
I
order.
might have directed you or passed an order. I have not instructed. Yes.
Your lordships, this is an NDPS matter, your lordships. I need some time to prepare the written note of
It
argument.
will remain in the list.
Your lordships.
Get prepared and come.
Yes, your lordships.
Yes. 85 था ना?
55.
Yes, sir. आप 80?
83.
Yes.
Convicted under section 20B2B of the NDPS Act. Was 5 kg, 500 grams of ganja was recovered from the appellant lords in a busy locality of Dharampur town. He was holding a bag. From the bag, that 5 kg, 500 grams.
Yes.
Lords, lords, he has been sentenced to undergo 5 years RI and to pay fine of rupees 5,000.
Yes, 50,000.
50,000 in
50,000 and 1 year.
in default.
Default, yes.
Lords, my case is the very pinpointed, lords, non-compliance of section 50.
50.
It's a personal search. And my case is that, lords, a member of raiding party cannot offer himself to be a gazetted officer and he can conduct the search.
Yeah, recently I passed a judgment on that.
Today,
No, few days back I passed.
lords, no, I'm not aware of that, but I'm relying on
You
judgment.
have your own judgment,
Lords,
some Supreme Court judgment.
relying on the
How the trial court deals with it?
Lord,
Let us see.
para 11.
Para 11.
Para 11.
Yes.
The learned defense counsel further argues that in the instant case, there is violation of mandatory provisions of section 50 of the NDPS Act, which entitles the accused to get an order of acquittal. In this regard, law is well settled that the provision of section 50 of NDPS Act applies only in case of personal search of a person, and it does not extend to search of a vehicle or a
Then,
container
yes,
or a bag.
Bag and all. This is the law.
It's no quarrel over
Yes,
that.
yes.
Bag means bag found in an isolated place, or just the first case your lordship was listening today, that bag was found in a compartment, railway compartment. But here, the para 6 your lordship will find, para 6 of the judge.
6.
Yes.
Yes.
PW2 Sri KK Rao, the inspector in charge of EI and EB Dharampur, who has detected the case, has deposed that on 16/4/2008, while he was performing patrol duty in Utkola Ashram Road of Dharampur town, at that time he found the accused Jagannath Panigrahi moving in a suspicious manner with a jari bag in his hand near Ganjam Kala Parishad.
In his hand. Huh?
Man.
It's an exclusive and conscious position.
And therefore he detained the accused, and by disclosing his identity, he asked the accused regarding the contents of the bag, who disclosed that there is ganja inside in it, and therefore he called the independent witness, namely Tuna Naik, and gave option requisition to the accused in writing as to whether he wants to be searched by a gazetted officer or any magistrate, and accordingly the accused gave written option to that effect, that he has got no objection if such by him, PWP, the said written option given by the accused is marked like Exhibit 4 in which so and so is the signature. PW2 has further stated that by observing all procedural formalities, he sought the accused and recovered the ganja
From him.
Well, ganja bag from. Well, this juncture, my lord, sir, I'm sorry, I was not aware of your lordship's judgment, but
Yes, no problem.
belonging and the judgment of Mission number 2, 98.
Yes.
Justice Datta's judgment, my lords.
Which
Exactly, my lords, in that case, the contraband was opium. He was holding in a bag.
Which paragraph?
Para 5.
Yeah, in the bus stand carrying the bag.
Mal.
Carrying the bag in hand.
Mal. There, the circle inspector who was present, lords, he was a member of raiding party, he himself offered to be a gazetted officer and search was conducted.
Yes.
There, this honorable court said that he cannot offer himself to be a member of raiding party, cannot offer himself to be a para 5 and 6.
Para
5 is the discussion. 6.
There, what the judgment which I have given, there it is, this story was the gazetted officer was taken along with the raiding party.
Okay.
He was called
no,
and he accompanied.
Yes.
He was an independent gazetted officer.
That is the case.
You can't accompany. You have to requisition. Then how do you know that it's something you are going to recover? How have you taken it? That was the, so therefore, the idea, the object of this thing is an independent person who has nothing to do with the investigation. Has to be there at the time of search. That is the whole idea.
Here in
the
this
inspector
case,
himself declaring himself to be the what you call gazetted officer can't do it.
That's the law. Here in this case, my lords, PW2 and PW. PW1 is the constable, PW2 is the IO. Nobody else.
The IO himself is the gazetted officer.
Gazetted officer. And search was conducted.
As noticed earlier, the search and seizure conducted in presence of the gazetted officer and the department of raiding party. Legislature intended to safeguard para 6. Safeguard the liberty of an accused and the safe false criminal case as from section 50 of mandatory provisions to be complied with strictly before conviction can be made, and at least it is not also. Then compliance of the provisions of faith regard to the search and recovery. So we see the proceeding and have discussed clear. The reason stated above, if it is entitled to succeed and so on. In this case, search was conducted in presence of the circle inspector.
Circle inspector. Who was a member of raiding party.
Member of the raiding party. He himself was a member of the raiding party.
Raiding party.
And as such, there was no compliance of mandatory provisions of section 50 of. But the case which I dealt with, there the gazetted officer was also member of raiding party. Gazetted officer was called. And he was taken along with that. Yes.
That is the only point.
Yes, madam, what do you say?
Then that they have given the option whether he has to be searched by the gadget officer or my lordship kindly have to glance to para 6, my lord.
6 up.
Page number 4, judgment.
Judgment. Okay. Yes.
That issue, my lords, I do not quarrel. He cannot offer himself to be a gazetted.
What he says is he himself being the officer and part of the party, raiding party, he himself can't be gazetted officer for the purpose of 50. He has to requisition an outsider who can come and do it.
Yes.
But he himself can't be a party to that. That's the judgment. Have you read the judgment? Read the judgment. There are many judgments. Let us see IO, what IO says. Let us come to IO. There are only two witnesses you have examined.
There is no quarrel over that. I am not entering in that only non-compliance.
15, see, IO is number 2. Just see, he is the circle inspector. No, he is the IAC. Yeah? I found the very way.
IAC, EI, and
Moving in suspiciously on the road with a jerry bag in his hand.
Yes.
He was holding hand. So therefore it is inseparable. It tantamount to personal search.
Personal search.
Personal search. So 50 steps in.
Yes, my lordship.
Now what he did, therefore I detain him and by disclosing identification asked him regarding the contents of the bag, and he disclosed the bag contains ganja.
Another is saying that
And
it was
thereafter I
ganja, my
called
lordship.
the independent witnesses, namely Tuna Naik. And unfortunately, independent witnesses are not examined and gave a written option to the accused whether he wants to be searched before the gazetted officer or nearest magistrate. And he said that option requisition exhibit so and so is my signature. And they so and so. So this is the, according to the accused gave a written opinion, option to the effect that he
Yes,
has
Lordship.
got no objection if he is searched by me.
By me means,
What was the option given?
my lordship, it was given before the gadget officer.
No, the option was given whether you want to get searched through a gazetted officer or a magistrate.
Nearest magistrate.
Okay? And what has he done? He himself did it. Has he said that I am also a gazetted officer to that extent at least? Has he said I am also a gazetted officer, I am entitled to do anything of that sort? No. He's asking something, doing something else. The clear-cut case of equity.
other aspect is that Tuna Naik, the APP has declared.
It's all right. There is nothing.
Yes, ma'am.
And equity, section 50. इसको PW1 and PW2 दे दो और exhibit एक मिनट exhibit exhibit 3 ठीक है 1, 2 and exhibit 3 yes and दे दो yes
77.
Yes, sir.
Let the petitioner charged under section 341, 307, 323 and 294 of the IPC. Since it is trial by a session judge, it has been transferred to SDJM to session judge. Ultimately, session judge took the evidence and wherein PW 6 and 7 turned hostile. PW 8, the doctor who said that the injury is simple in nature, and there are some also investigations are delayed after 1 month after registration I have, and medical lathi that lathi in Kosi, what it was not measured, and PW 9 the investigation officer also said that it is a floppy investigation. And ultimately I was not found guilty under section 341, 307 and 294, but found guilty in 323 and imprisonment for RI for 1 year and fine of 1,000 rupees. My lord,
convicted 323.
322 only. And my lord, kindly have a look to the.
You said you have already undergone majority part of it.
My lord?
You have already undergone.
No, I was through
bail.
Since the offensive trivial nature. My lord, kindly have a look at the PW1. The evidence of PW1.
PW1, huh?
It was in page 14.
Okay. PW1.
Page 14. And you got it? PW1, just the middle of the Riverbank Court. In the elder
PW,
brother-
you are reading the
Running
judgment.
Running page 14, but the judgment page at 5.
Okay. Yes.
PW1.
Para 5.
Para 5.
Yes.
PW1, Riverbank Court. Is the elder brother of the informant, injured person, responded report. He deposed that on 9/12/1, so he was purchasing paddy from one Biharilal Bahera, and he had engaged labor. Accused person quarreled with him when he asked why accused person has raised the price of the paddy. Accused person assaulted the responded report by means of Kerengla. That is a
Lathi fixed in.
bullock cart to control the bullock. And the assault landed on head Port, who sustained bleeding injury on his head. The injured person was taken to Jagdalpur Hospital for treatment, and there is no doctor at Jagdalpur. He was taken to Padmapur Hospital for settlement of the dispute of the village health. A report was lodged in the police station. On cross-examination, it is recited that police on receipt of the FIR delayed investigation for about 1 month on taking pretext of the they are having work at Bolangiri and Bargar. Police did not take any action to treatment of his brother Padmampur Hospital. The injured person was treated at Padmampur Hospital without getting police requisition. Police has delayed investigation for 1 month. The seizure was effected 1 month after the occurrence. The above laxity inaction of police has written bearing on believable prosecution narratives. That was the observation. My lord, kindly see the top of page 6 below bottom. In presence of convincing evidences on record, the narratives of the prosecution case without dent on it required to be believed. Particularly the injury on the person of the injured person is on the head, and same is not the possible by self-infliction. There is a doubt on the mind of the learned troll force. That is not possible by self-infliction. P2, preamble force. Then suppose that at the relevant point of time, he was cutting wood for pitching purpose and found the accused person and the injured person were engaged in quarreling with regard to paddy purchase. The accused person did not agree to pay the expenditure to the injured person. The accused person assaulted by means of Kerengla.
The appellant is convicted alone. Alone.
And on cross-examination, on the middle of the...
Let us see the evidence. Yes. 77, Jayant, yes. Come
on
to...
the cross-examination, he did not specify that I was...
No. See, who is PW? He is PW?
PW4.
4. Come to PW4. Evidence. Let us see evidence.
He stated that on cross-examination, nothing is substance...
No, are you reading? Don't read the judgment. Judgment may be wrong. Therefore, you are here. Read the evidence. Do you have the evidence with you?
May I plus?
No, does he have the evidence? Do you have the evidence with you?
No, the evidence.
Oh, you have not read the evidence. Read the evidence. Don't read the judgment. Judgment may be wrong also. But don't take chance. You take out the see, there are 9 witnesses.
Yes.
Just read the evidence. Only impugn judgment you have read.
Yes.
Impugn judgment is wrong, therefore you are here. You are reading a judgment which has gone against you. You read the substantive evidence, you can find out many. Only 323 convictions.
Yes.
You see the injured witness and the doctor. Who is the doctor?
Doctor, that investigator, doctor, PW.
PW?
PW number. PW5. Dr. Jadumani Saab deposed that on 9/12/2007 he had examined the
He found 2 injuries.
He said that
lacerated is situated in the horizontal clap of the front, so the injury is simple in nature.
Yes.
And caused by hard and blunt object, and duration of the injury 24 hours. Period of examination, time of examination.
And IO himself said that I have not seen the seized materials and not measured the sticks. And also
when the incident had taken place, That on-
Incident took place on 9/12/2007 at about 11 AM.
So then if you come to PW 5,
Yes.
he says on 9/12/2007, I was attached to so-and-so hospital, Padampur,
Yes.
as a medical specialist.
Yes.
On the same day, on the police requisition and the order of SDMO, Padampur, I examined the witness. So then you say that police has not requisition
But
for
judgment,
1 month.
judgment it has been.
So therefore judgment may be wrong.
Yes.
He
has taken
police
that
has the requisition.
position in the.
That's it.
Yes.
Come to the doctor's evidence. Doctor says that on police requisition he did it on the same day.
But the.
And see the injury.
Ultimately injury is simple in nature. He did.
So therefore 323.
323.
Therefore 323. That is the reason 307 was the charge. You have been acquitted 323.
It is a self-inflicted injury to only.
So you substantiate that self-inflicted. Have you suggested that to the doctor?
I said if the investigation is floppy in nature and he has not identified the major stick.
Read the doctor's evidence in para 2. Para 2, the police made a query on producing one wooden stick on 11/5/2008 and resorted opinion from me. And I opined that the injury in Exhibit 3 can be possible by the weapon of offense produced before me. You say self-inflicted. How will you doubt this doctor? Also, I opined that the weapon shown to me can cause death and if assaulted forcibly on the vital part of the body, like the head of a person. And this is my report in Exhibit 4. And Exhibit 4/1 is my signature therein. This is the doctor says. Injury mentioned in Exhibit 3 can be possible on fall over and blunt surface. I received the query requisition on 11/5/2008 and I submitted the report on 12/5/2008. At the time of the treatment of the weapon of offense was not shown to me, and it is the fact that the length of the weapon is so and so. It is not a fact that I have not examined the injury and the doctor so. These are the evidence. You will get over the evidence.
He said that the injury may be might be falling.
How do you know? He said you have not read the evidence. Evidence is not there with you. Don't take chance. Read the evidence. I'll take it up at 2 o'clock. Evidences are here. Only relevant to witnesses, 2 or 3 witnesses are there. Just go through. It is there. I'll take it up at 2 o'clock. I understood it. You just check it out. It is there. Somebody will help you. Print out the. ଆପଣ ପାଇଯିବେ ସବୁ. Yes. Yes, sir.
Item 79. ଦୁଇ ତିନି ଥର ସବି ମାଇଲଟ କିନ୍ତୁ ସ୍ଲିପ୍ କରିଦେଇଥିଲି ସେଥିରେ ମାଇଲଟ ଅର୍ଡର କରୁଛନ୍ତି ଏନି କେସରେ ଆଇ ୱିଲ୍ କଣ୍ଟାକ୍ଟ କିନ୍ତୁ ସେ ଫାଇଲ ଟିକେ ମିସ୍ ହେଇଯାଇଛି ବୋଲି ମୋର ଟିକେ
already appointed MAKS kuri.
ତେଣୁ ମତେ 15 ଦିନ ଖଣ୍ଡେ ଟାଇମ ଦେଲେ ବି ମୁଁ
I have said that if you don't appear, then I'll appoint. Now you are appearing, it's all right. I'll not appoint. Paperwork paperwork system is already redundant. You have to take it in your pen drive and get it ready. Let it be there in the this list only. You take it in the pen drive, get ready and come. No problem. I'll accommodate.
Then 2 weeks time.
Not 2 weeks. It will be remain in the list. You come after 2 weeks. I'll take it. Don't worry.
Mala Sam is in the 49. My brother is there.
I have told him to accommodate because it is 2009 matter. The matter is 90s, then I'll not do.
No, I am submitting one thing.
Which one?
Item 49.
49. 49 is which year matter?
My brother is there. My lord is pleased to appoint me as amicus curiae. My name may be deleted because he is there.
Acha. 2002. That's the problem, Mr. Joshi.
Yes, please.
We want to appoint someone. That's the whole difficulty. We might have read it also. Anyway, Mr. Mishra will be entrusted with some other serious.
36 may be taken up on Thursday, Madam.
It will be taken up. Let it be there in the list. Mr. Joshi, are you ready?
Yes.
Ready?
My lord, friend Mr. Naik is saying that he is not ready.
We are ready.
File नसला तर पहिलं file টা नाही.
I'll take it up 2 o'clock. You read it. Let him read also. Let him read.
अरे सर 2 o'clock 1 hour last hour 3:30 ପରେ 4ଟା ପରେ
You get ready and come. I'll take it up.
yeah. Because 1 hour I have got.
Otherwise, Thursday also I can take.
Yeah, Thursday will be better. In the meantime, I will take copy of the deep from.
Yes.
Sir, 24
Yes.
Unable to trace out the petition, about the petition.
You forget about the petitioner. You are there. You do it. It is. It will be remain in the list. Take it from here. Take it from here. Get ready.
In soft copy.
Yes. If anybody is ready,
38 I'm ready. Item 38.
38. Yes, 38. Yes. Yes, Mr. Das.
Yes, my lord. Two appellants are there, my lord. They are facing trial under section 452, 304, 307, 325, 328, 323, along with 31X of SC/ST Act, my lord.
Yes.
But convicted under section
Nokulo Godo and Bobby Godo. Huh?
Ravi Goda, my lord. And
Yes.
convicted under section, my lord, 325 and 34 of IPC, my lord.
Yes.
The rigorous imprisonment of 2 years and fine of 1,000 rupees in each. The undergone period, my lord, 223 days.
Undergone?
223 days, my lord.
Yes.
My lord. Total 11 charge sheeted witnesses, my lord, out of which 9 witnesses has been examined by the prosecution, my lord. And no eyewitness there, my lord. If PW 5
Who is injured?
injured, my lord, PW 2 to 4.
Achha,
And one deceased person is there, my lord. Deceased.
Let us see 2, huh?
PW 2 Vasanti Naik, PW 3 Narush Naik, and PW 4.
Let us see PW2. First injured.
My lord.
Yes. I know the accused persons who were good by classes.
And PW 6 is the doctor, my lord, who conducted the autopsy of deceased.
Come to PW2.
My lord. The wife of the informant. I know the accused persons who are board by car, who are part of my car, deceased. Budhurai was my mother, and my father-in-law. 10 months ago, in the month of Chaitra night, at about 8 p.m., myself, my husband, Vika, my mother-in-law and father-in-law were there in our house at Bali side. At that time, the accused persons came to our house and challenged my father-in-law as to why he has become a witness against them in Mochi Night case. Accused Nokodo was armed with a Kati and Laki, and accused Babi was armed with a Laki. The accused persons abuser saying so and so, and then Babi dealt Laki blows on the right hand and right leg of Narsu. After this Laki blow, my father-in-law fell on the ground. When my mother
Try to cover and save my father-in-law. Accused Apula dealt lathi blows on her back and gave thrusts with a lathi on her abdomen. My mother-in-law collapsed and became unconscious. Then accused Apula dealt a lathi blow on my left hand above the elbow, causing bleeding injuries. When the accused person fled away towards the police. This is the prosecution case. My husband, Mika Naik, and myself.
Mother-in-law died, huh?
Mother-in-law died.
He became crippled. Yes. And PW3 is also injured?
PW3 is also injured, my lord. Is the husband of the deceased, my lord.
Husband of the deceased. That's the father-in-law.
My lord.
PW3, huh?
My lord. Narush Naik.
So injured, they are the neighbor.
So he was not present during the occurrence, my lord. Devraj Naik was not present.
I fell down. Accused Nakulo dealt a lathi blow on the wrist and abdomen above the songs. Collapsed and lost her senses. Yes. Who is doctor? Doctor?
The doctor is my lord. PW 6 and 7. PW 6 is the doctor who conducted autopsy of the deceased body. My lord. What he says, my lord.
Basanti Naik,
Mother-in-law who died.
who died, huh?
Yes. Paragraph 3, deposition of doctor, PW6.
Before that, my lord,
And who has examined PW3?
PW3 examined by PW7, my lord. Another doctor.
Okay. No. At 2 p.m. conducted the PM report of so and so. No. PW6 is the PM doctor.
Yes, ma'am.
Budhuvari. And PW7 is the
Injured person.
injured person.
What PW6 says my condition?
PW6 is not necessary because you have been acquitted.
Yes, madam. In 302, we have been acquitted, madam.
So 325. So therefore, just see PW7.
Paragraph 6, ma'am.
PW?
Paragraph 6.
Yes.
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 Paragraph 6, ma'am. Father-in-law was admitted to the hospital, but she died. So I sent information and the exhibit 11 in the exhibition and exhibit.
Oh, that's not the case.
No,
Just see.
Injured person first came to the treatment. Later on the police requisition for an examination kit, the injuries are possible as a result of assault in the treatment. That was in the process.
Basanti Naik was PW?
PW, madam, 2.
PW2.
Wife of the
PW2 is examined by
PW7,
PW7.
madam.
Okay. The same day examined Nasru Naik is PW? Nasru Naik.
That's a PW3, madam.
PW3.
Madam.
PW3 also he
By PW7, madam.
Nasru Naik. Possibility solved for just simple in nature. All these are simple in nature. Amar Naik, PW?
PW5.
Amar Naik, my lord. The independent witness who were turned hostile, my lord. And he is the son of
Vika Naik.
Naik, my lord.
Vika Naik, PW?
Vika Naik, PW4, my lord. The informant and the son of the deceased. My lord.
Just see PW7, just see. He has examined all the injured as well as the deceased. And insofar as the examination of PW4 and PW2 is concerned, he has given the opinion that the injuries are simple in
Simple in
nature.
nature. My lord.
Whereas insofar as PW5 and PW3 are concerned, he has not given any opinion regarding whether the nature of injuries are simple or grievous. Yes.
It is also important, my lord, the statement of the IO is also.
What is your case?
My case is that, my lord, there is no independent witnesses to show that we have committed the crime, my lord. And there is a lot of discrepancies with regard to the
Why should the injured witnesses will be disbelieved?
my lord,
They have narrated the incident very succinctly, and everybody has said the same thing.
the judgment was said that, my lord, two lathis were, my lord, recovered, my lord. The lathis, the no SFL the report is there, my lord, to show the blood stain. My lord, kindly see the IO, what he says, my lord. So all the witnesses developed their case in the court, my lord. They did not say about anything else about the.
Who is the IO?
Who is the IO, my lord? PW9.
Yes, PW9. Yes. Where does he say that?
In the cross examination, PW1, PW9 did not specifically.
Which paragraph?
Paragraph 5, cross examination.
Yes.
PW1, Devrat Naik did not specifically state to me that accused Babi Gowda dealt lathi blows on the right hand and right leg of Narush. It is a fact that PW1 did not state to me that when deceased Gurubari tried to protect her husband, both accused person dealt lathi blows on her. PW3 and Ashu Naik did not specifically state before me that Babi dealt lathi blows on the right hand, right leg, and that Babula dealt lathi first on Budhuvari. Budhuvari the deceased fellow. PW2 Vasanti did not state to me that accused Nakula gave lathi thrust on the abdomen of the deceased. On the statement of the accused persons, Exhibit 13 and 14 have not given any endorsement. I read about and
No,
explained
this is neither here nor there. The witnesses have said there was a clear motive behind it because the father-in-law, the PW3, had deposed against him in one of the cases. So therefore, these people went and attacked. And the only thing what goes in your favor is it could be a case of 323, not 325. Never on that. I'll take it up at lunch, after lunch. It will be a maximum, it will be a case of 323 because the doctor has said insofar as two injured witnesses are concerned, he has said the injuries are simple in nature. And insofar as the other two witnesses are concerned, he is silent about it, what is the nature of injury. So then how you bring 325?
My lordship,
the Kati was also not recovered, my lord.
That is an incidental thing.
that, because my lordship.
Read the evidence. Might be so many things, but if so.
Some, my lordship, here, because of the case was started when he has, a father was given some witness for threatening my lordship.
That is motive is there, everything is there. I am only asking one thing. how will you sustain 325? It should have been a case of 323, max to max. You justify that. Both of you read on that line, whether it should be 323 or 325. In prima facie, the evidence which I have just glanced through, it looks like a case of 323. See, the deceased who died, the doctor says that visibly there was no external injury. And
This-
apparently there is no internal injury.
Yes, my lord.
There is no injury. So that is the reason 302 is ruled out.
The IO also says that, my lord, during investigation, I had not material to show that a previous enmity was there between the accused person
See,
and the informant's family, my lord.
I replied that the death was natural one, not the homicidal one. So therefore, that is the reason 302 is ruled out.
My lord.
The doctor says that it is a natural death. There is no external injury, there is no internal injury. She died. So therefore, 302 is, see, the important witnesses PW6 and 7. PW6, who examined the deceased PM doctor, he said that is natural death, so 302 goes.
The statement of the IO is also important.
Now it is only 7. Just read the 7 and tell me. Do you have exhibits?
Yes, my lord.
Just see the exhibits. Whether in the exhibit any this thing is there, simple or grievous. Just check it. Check the exhibit, medical record, and tell me. We'll continue. Continue at 2. Continue. Just see the exhibits, the medical documents. Anything is written, whether it is simple or grievous. If it is written grievous, then we'll think of.
Item number 73 and 86 may be taken up some other day.
Need not see it. It will remain in the board.
Yes, sir.
Yeah? No.
Some other day, we have
Yes.
to obtain the answer.
Where Mr. Das was doing it, where is Mr.
86. 73 and 86.
So the matter which I was hearing, Mr. Das.
Someone else. 38.
Leave it. Leave it. No, leave it. Yes.
Not give the 323.
Why?
Because was submitted against 325 and 30. My lordship kindly have glanced to the deposition of PW7.
7. Okay. Yes.
Paragraph 2.
Para?
On the very same day, also included.
Narsu Naik, so and so, and found the following injuries. Yes.
Date former.
Yes, all these three.
My lordship will see.
No, they read it then. Since it was not possible to say whether there was a fracture without specialized examination, I refer the injured to specialist. Reference is there.
Yes, ma'am.
Hmm.
That is the suggestion given for the surgery. Exhibit 7.
Yes.
My
He
lordship
only referred it.
referred.
Yes.
But my lordship, she knows that there is an injury. In the exhibit also it was found that there is.
No, he says whether it is simple injury or grievous injury.
Injury.
Then 323, that's what I'm saying. Section 45. Yes, section 45. Yes. Read it. When the court has to form an opinion.
On 20 of finger impression, the opinion upon that part of the person specifically skilled in such foreign signs or in question or activities of the handwriting or finger impressions are relevant facts. That person are not and my lordship kindly come to the comments. Comments. Medical expert is the evidentiary value. Medical evidence is only an evidence of opinion and is hardly discussed. This is only an opinion. Who cannot.
Then your case is further worse. Then how will you establish if it?
Then my lordship can say the medical opinion being an opinion is an adversary in nature and not binding upon the court. The court has to form its own opinion considering the material matter and opinion on the technical aspect rendered by the medical expert. Here my lordship kindly come to the judgment. It is page 9 of the judgment, paragraph 10.
Page 9, para?
Page
1 minute, madam. Page 9. Internal page 9 or running page 9? No. Internal page. 7, 8, 9. Yes. Regarding the attack.
Right here, the version of this witness find clear support from the extract exhibit 3. The evidence of the Dr. PW7 also indicate that while examining Narsu he found fracture on the right leg and some injuries on the left. So substantial support is also available from the medical evidence. The ocular witness have not spoken about the growth of the left hand of Narsu, but such omissions are possible when the indiscriminate attack took place. The evidence on record therefore clearly establishes that the Narsu sustained fracture and other injuries on his person as a result of a knocking blow inflicted by the accused person. Fracture is undoubtedly a grievous injury, and so the accused person would be liable for purpose of repetitive and categorical. And here, my lordship, in section 330 of the it is already clear what is the grievous cause. In the grievous act, it was said that 320 grievous aggressive. 7, my lordship, fracture or dislocation of the bone of the is a grievous injury.
Come to PW7 again. (54) Read it. Since it was not possible to say whether there was fracture without specialized examination, I refer the injured to the surgery specialist. I take your argument.
Yes.
Then,
Then exhibit 7.
well, show me exhibit 7.
Yes, ma'am.
That's what I was saying. Exhibit 7. Exhibit 7. Mhm. X-ray and anything is exhibited. No,
No, my lordship.
Then-
My lordship,
then
not so like.
it is not conclusive.
My lordship, it was not it is not there in the exhibit.
It's there. It's there. Just see.
Here it is not there. my
Exhibit 6. Click exhibit 6 and thereafter just see. Just see 6. Exhibit 6. Click exhibit 6.
lord.
Exhibit 6. Thereafter next document is exhibit 7. Next to next document. That is exhibit 7 here. Exhibit 7.
Page number 89.
But it is Amman Naik, my lordship. It is Amman Naik. It is not a Narsu Naik. I am talking about Narsu Naik, my lordship. I have honor to forward here with the result of my examination, Amman Naik. Exhibit 7 is not there, my lordship.
Nurse Naik is there.
Yes.
The PW, and 6 is Vasanti Naik. Okay? And thereafter you just see, then next also Vasanti Naik. Okay?
Yes.
Thereafter you see examination. Bhagavan kya hai? What is this?
Bhagavati Naik.
Bhagavat Naik. You leave it. Huh? Thereafter you come to,
Amman Naik.
yes, I have request to examine Nurse Naik.
But,
Yes.
but it is.
Examine Nurse Naik. So. Then it is handwritten. It is less. So 8 p.m. the above mentioned has been pull. Please examine. This is the requisition.
Yes.
Exhibit 7/2 is the requisition for Nathu Naik. Okay. 7/2. Where is the examination? Amar. Except Nathu Naik, everything is there.
Yes. Ma'am.
It was, whether there was a fracture or not, that is not ascertained. There is nothing on record. There is nothing on record. Yes, anything else?
No, my thought.
But this paragraph is creating problem for you. Grievous, how will you conclude grievous? You say the fracture injuries are grievous injury, no problem. There, no problem. But the doctor himself says that it cannot be ascertained whether it's fracture or not. So therefore, he refers to the another hospital for X-ray, and that has not been done. So this remain inconclusive. So therefore, it could be only 323. 323. Okay, 3.
My other kind of lost with the 700.
You've undergone about 223 days.
Yes, brother. 223. Arrested on 8/4/98, my lord.
8/4/98.
98.
8/4/98, yes.
Then released on bail 17/11/98.
17/11/98. 98. Okay. This court when it. Okay, yes. Good. Okay, thank you. Yes, sir.
I invite your lordship's attention.
Another item, my lord, item 50 is there, my lord. That may be taken up. I'm okay.
Ready to Thursday? We'll take
Yes,
it.
but
Yes, sir. Item?
Deposition of doctor, PW5.
Didn't
Dr.
file.
Chaudhary Sahu.
Yes.
My lord, I'm placing that deposition. On Nov 12/2007, I was attached to SD Hospital, Padambur as medicine specialist. And on the same day, on police requisition, order of SDMO, Padambur, I examined the Vishwandeva Port, son of Udhav Port of village, so PS Zarman, and found following injuries. Laceration of 4 cm and so and so.
Yes, injuries are simple. Injury is simple in nature and caused by hard and blunt object.
Yes.
And duration of injury shown.
And it is, my lord, it has been also said, cross examination, injured masonry X-ray can be possible on fall over the hard and blunt surface. That was suggestion and he has answered. I received the core requisition on 11/5/2008 and I submitted the report on 12/5/2008. It is very important. At the time of treatment, weapon of offense was not shown to me. That is very important. But IO said that I have sent weapon to the doctors, PW9.
No, where offense? At the time?
Kindly see.
Oh, subsequently it was shown to you.
Well, it was not shown to him, but IO said.
Shown at the time of examination of the injured. That time it was not shown, subsequently it was shown.
But PW9, my lord, his statement mechanism PW9.
Yes. Yes.
My lord, Surendra Swami, the IO. On 12/2, I was ASI of police attached to Jagatpur. On that day, I received the written report lodged by Switching of informant and forwarded this same to
You show me the relevant part.
And the relevant part is that and I am showing his crossing. I have examined PW1, Jibardhan Port. He was not stated me that on getting assault by the accused person, the injured person fell down and he was taken to Jagatpur Hospital, where there was no doctor. Thereafter, he was taken to SD Hospital, Hon'Ble. The witness volunteered that at Jagatpur Police Station, doctors are not available. Length of MO1 lathi is 3 feet 4 inch. It is a fact that the length of lathi is written as 40 centimeters. My lord, it is 3 feet 4 inch, he said, but thereafter he said the length is 40 centimeters.
What's the date of incident?
My lord, date of incident, my lord, 9/12/2007 at about 11:30.
12?
2007.
FIR?
FIR, my lord, on this. FIR lodged.
FIR is lodged.
10/12/2007.
16. No. FIR was registered on 10/12.
Yes. 10/12/2007.
10/12. Incident when you said the incident is
9/12/2007.
9/12 incident. FIR 10/12/2007. Yes.
And my lord, that procedure witness, my lord, it is that I have left it. It is not a fact that the weapon of offense which was not sent to the doctor. The weapon of offense MOI Kerala covered under the with clothes with steel is
Where are you reading?
My lord, that cross examination IU.
Para 5,
Para 5.
Para 5.
Yes.
I have examined PW1 Jibardhan Port. He
Yes,
has
I
not
have
stated
sent
before me
I
that
sent the seized lathi to the doctor.
Yes.
It is a fact that the length of the lathi is
is 3
written
feet,
in
4
40
inch.
centimeter.
And it is
I had sent the seized lathi to the doctor.
I had sent to the lathi to the doctor, but doctor says that it was not told to me.
No, he
Doctor has
says so
stated.
it was shown subsequently.
In para 2, doctor has stated.
He said it was shown, it was not shown at the time of examination, but subsequently it was shown to him. And he gave opinion on that.
But my lord, that was the factor. And my lord, seizure
In the
witness.
8th of May 2008, 8th May 2008, the lathi was shown to him.
PW5 para 2. Police made query on producing one wooden stick on 11/5/2008 and resorted opinion
11/5
from me. Yes,
11/5.
11/5.
11/5.
I opined that the injury in Exhibit 3 can be possible.
Subsequently, the weapon of offense was shown to the doctor, and doctor gave the opinion. Yes, this is possible. With this weapon, these injuries are possible.
Yes. He also opined that it can happen on the falling of the.
That is one of
my lord. And the seizure witness, my lord, PW 6. PW 6, my lord.
Yes. PW6 declared hostile.
PW 6 declared hostile. PW 7 also declared hostile. My lord, thereafter, Junu Singh also, Junu Singh, PW 8, my lord.
See, read PW.
PW 8.
No, PW 6 also read. I know the person also.
Yes.
Occurrence took place on Saturday also.
I can say the date.
I had agreed
time,
to
procedure
send
and
the
everything. Yes, yes, ma'am.
also per acquaintal. And the agreed person came and raised the rate also and asked to send the PD. As I agreed to send the PD also, 2 level of the informant came and there were both accused persons and informant. quarrel. The quarrel part is there.
Yes, there was a quarrel regarding
And I
purchase of
cannot
land.
say what happened thereafter. Quarreling part is admitted, even if he is hostile.
And apart from that, the evidence of the injured corroborated by PW2, who is an eyewitness to the occurrence.
And if you come to part 7, Rule 7. Rule 7 is in process, thus we have packed 10 bags of rice after owing from house of Kunja Vihari. Kunja Vihari was present when we were paddy. Nobody objected when rice was weighed and packed. That part was that nobody objected, there is no call, nothing. Prosecutions of PW 7. Madhu alias Sushil Vishwa. Yes. Yes, my lord. Therefore, offense under section 323 also not made out for the prosecution, not proved by. 323, according to me, is made out. That's the problem. You should tell me something else. Now the both parties are pulling away. What my information, I got it. What do you say?
You are to.
I'll grant PO. I'll grant PO. Oblige. He has no antecedents also. And therefore I will grant PO. Oblige. Much oblige.
Your Lordship, item number 44. That the appellants were found guilty of offences under section 148, 145, 324, 332, 452 of IPC.
Item?
And convicted to
Item?
44.
Yes.
And convicted to under the rigorous imprisonment for 3 months and to pay a fine of rupees 500 each on each count, and in default to under the rigorous imprisonment for 15 days more by the additional sessions or iron food. Under the sentences are to run consecutively. The lordship last occasion, on the last occasion, the lordship directed whether to PO Act.
What are the offences you say?
Again?
What are the offences convicted?
148, 149, 324, 332, and 452 of IPC.
How many of you are there?
Total 6 numbers.
What is the substantive sentence you said? Sentences are three months, huh?
Okay.
500.
3 months, 5.
Under, for the period of 15 days.
5 days.
Yes. What do you say? You know, 3 months of, I grant you, huh?
I'm also relying on the document.
Do. Which paragraph? Which paragraph?
The para 13. The PO Act. Oh, PO.
Not many cases. It's my judgment only. In many cases I have given. Okay. Anything? Ready?
My item is 47. In that matter, the conducting council could not appear for.
That will remain, huh? That will remain. Get ready. Oh, ଆମର କେତେ ରହିଲା ରେ ଆଜି? Total?
जी total 6टा था.
6 appeals. I think 6 appeals is enough. I'll have to give dictation now. Visually. 6 appeal per day is on an average small height. Okay.